Well, it matters because with employment claims, before the employee can go straight to court, they must file through the EEOC first, the U.S. Equal Employment Opportunity Commission. And you don't need a lawyer to do that. We handle EEOC representation, but the first step is to file an EEOC charge because that gives the agency an opportunity to investigate the employer. And most importantly, EEOC issues the right to sue. So the employee needs that golden ticket before they can file suit.
So a lot of people think, okay, I lost my job. I want to keep it on the down low. I don't think my other employer is going to say something bad about me that may not give me a recommendation, or maybe they said they would give me a recommendation, and I just got fired, and I think it was unjustified. Um, and then they say go to EEOC, and then they're thinking, if I go to EEOC, then that's going to go back to my former employer, and it's going to ruin my reputation, and it's going to follow me for the rest of my career. How does that all work? So how do you kind of allay those fears? Because these are all real fears that I'm sure you've heard this over and over.
That is a huge concern, and it's a valid concern. Nobody wants to be bad-mouthed to a subsequent employer. It is um, it's a huge concern. So what I will say is that the EEOC, well, the law prohibits retaliation from an employee who participates in protected activity like filing a claim with the EEOC. So this means that an employer can be punished even further if they're bad mouthing or talking negatively against the employee in order to, like torpedo them from a potential job offer. What we can do in many instances is negotiate a neutral reference with the old employer, so the employer is only permitted to disclose position and length of employment with the company, and they're not allowed to say anything else about that employee.
So I know a lot of employers just do that as a matter, even if they're going to give a good recommendation, they don't give any recommendation just because of that very issue. So, is there anything an employee almost always does in the first 48 hours that makes their case harder to win?
When an employee resigns, it makes it incredibly difficult to proceed on a legal claim because the employer has a defense to say, look, we didn't fire that employee. They quit. They had an open offer of employment and they decided to quit. So before resigning, think about it or consult with an attorney so you can figure out your best options. But also, um, certainly, taking anything with you that belongs to the company could get you in some hot water. Speaking publicly may not enhance any legal claims that you might have. So I would consider speaking out on social media or speaking out publicly if you think you might have some legal claims against the company.